Your comments matter, and not just the comments underneath this video. The ATF has just released their latest rule, definition of engaged in the business as a dealer in firearms. The rule has changed significantly thanks to the comments of GOA members. Today, we're going to look at those comments and break down how ATF's rule has changed because of them. Hey guys, I'm Tiffany and you're watching One in the Chamber, the show that helps you become a better pro-gun activist. Before we get into this video, please take a second to like, comment, and subscribe to help us fight YouTube's algorithm. In 2023, the ATF announced their rule, definition of engaged in the business as a dealer in firearms. The rule mandates that all gun sales be done through a licensed dealer, and therefore guarantees that at some point, the paperwork will wind up in the hands of the ATF on their legal digital registry of gun owners. And in September of 2023, ATF posted the proposed version of this rule to the Federal Register for public comment. And for those unfamiliar, when any government agency issues a regulation, they must first open that regulation up to what's known as a notice and comment period. Basically, this means that members of the public who are affected by the rule can let the agency issuing said rule how it would affect them. And this gives the agency the ability to change, or in some cases, retract completely the proposed rule. GOA has been successful in defeating ATF rules at this stage in the past. Our members helped us defeat an Obama-era ban on green tip ammunition when ATF proposed that rulemaking on the Federal Register. Well, in December of 2023, the notice and comment period ended with GOA submitting over 85,000 comments. And by law, an ATF employee had to read and reply to all of the unique arguments. Now fast forward to today. The ATF rule is out, and GOA's legal team has combed over every inch of it to prepare for our lawsuit. If you haven't seen it, go watch our press conference where we announced our lawsuit with the state of Texas alongside Attorney General Ken Paxton. Dissecting this unconstitutional rule, our attorneys found that ATF had to respond to our comments and our members' comments at least 39 times in the final rule. And these comments played an important role in reducing the number of issues that will be subject of a legal challenge, narrowing the scope of our lawsuits, and making them more effective. And in addition, these comments reduce the liability of gun owners under the new rule, and in the meantime, while our lawsuits make their long and arduous journey through the court system. So when anyone tells you that commenting is a waste of time, this video is proof that it isn't. Now, let's take a look at how the final rule changed based on those comments. First, ATF tried to add the text and business practices to the statutory definition of responsible person in the proposed rule. Expanding the definition of responsible person qualifies more people as needing a license. ATF was obviously working to widen this definition as far as they could. And in a response, we commented, clearly this regulatory definition is intended to and has the effect of watering the statutory language down in order to cover more people and conduct than Congress authorized. For example, a lawyer retained to provide regulatory advice to an FFL can indirectly cause the direction of business practices of a gun store, but clearly does not become a responsible person. Basically, if a lawyer gives a gun store legal advice and the gun store owner changes his business practices based on the legal advice, then ATF's proposed rule would have said the attorney needed to legally become a responsible person and get an FFL. Also, FFLs wouldn't be able to get legal advice without bringing an attorney on staff and making them pseudo co-owners on the gun store. Imagine how bad things would get fast for the firearms industry with ATF changing rules left and right these days. This could have been bad. As a result, ATF backed down and removed the term business practices from the definition of responsible person, both in the final rule and from dealer application paperwork in the future. Next, ATF tried to add a presumption that a person is an unlicensed dealer when they spend more money or its equivalent on purchase of firearms of the purposes of resale than the person's reported gross taxable income during the applicable period of time. And we commented that the phrase "the applicable period of time" is entirely ambiguous in scope, and a firearm purchase made while living off one's savings or retirement accounts would qualify under ATF's ridiculous standard, because a person making withdrawals from a savings account or a Roth IRA has no taxable income at all. So too would a purchase made using Social Security or VA disability benefits, or even a settlement from an injury, none of which are taxable. ATF backed down again, observing that there are several situations in which individuals with income that is not reportable as gross taxable income, such as those receiving disability or welfare benefits, retired firearms collectors, retirees drawing on Roth IRAs, and young adult children, would be caught up in the final rule. As a result, ATF removed this gross income-based presumption from the final rule. This is a huge win for retirees and veterans living off their benefits. The proposed rule also tried to presume anyone who advertises or posts firearms for sale, including on any website, would have an intent to predominantly earn a profit and, of course, guilty of being engaged in the business without a license. GOA commented that the rule would punish collectors and casual firearms owners alike, which shows ATF's extreme disconnect from the reality of the behavior of ordinary, law-abiding gun owners who are in no way engaged in the business. In response, ATF acknowledged commenters' worries that an advertisement for an isolated firearms sale might cause them to be presumed to have a predominant intent to profit, and the presumption has been revised to add the words repetitively or continuously before advertises, markets, or otherwise promotes a firearms business. The ATF also tried to presume that anyone who purchases, rents, or sets aside permanent or temporary physical space to display or store firearms they offer for sale would intend to earn a profit and would therefore require a license. We commented that this presumption is in outright conflict with the statutory protection for those who wish to sell all or part of their personal collection of firearms at a public location like a gun show, and literally every person who possesses firearms sets aside physical space to display or store their firearms, such as a display case, home gun safe, or even tucked in a nightstand drawer. As a result, GOA commented that this foolish and uncabined presumption would turn literally every gun owner who has ever sold a gun into an unlicensed firearms dealer. Yet again, ATF backed down, agreeing with commenters that collectors may set aside space to store firearms from their personal collections that they offer for resale, including at a gun show. ATF went so far as admitting that the proposed rule went too far by deleting the words "or store" and replaced the phrase "otherwise secures or sets aside" to ensure that merely setting aside space to store or display firearms is not included in the presumption, and that only persons who secure space at cost in order to profit from firearm sales are included. The ATF also presumed that anyone who purchases or otherwise secures merchant services as a business, like credit card transaction services or a digital wallet, through which the person makes or offers to make payments for firearms transactions, has the intent to predominantly earn a profit. GOA caught this and commented, "This presumption appears to target buyers of firearms who make electronic payments rather than purported dealers who accept electronic payments when they sell guns." And based on ATF's mixed signals in the proposed rulemaking, we argued that it is entirely unclear who ATF is trying to target with this presumption, buyers or sellers. And ATF acknowledged this error, agreeing with commenters that the presumption about electronic payment systems is meant to be directed at sellers and not buyers. Because of this, ATF deleted the phrase "makes offers to make payments" from the presumption, which now only applies to merchant services through which the person intends to repetitively accept payments for firearms transactions. We all know that giant billion-dollar agencies make mistakes all of the time. But if you comment and read these rules closely, you can point out all of these absurd mistakes and make a difference. And finally, the ATF grossly underestimated its affected population, using an outdated 2015 survey to suggest only 22% of Americans owned a firearm. GOA caught this and commented, "By analyzing outdated 2015 survey data, this study fails to account for the massive increases in the rates of American gun ownership in recent years." We then provided a more recent Gallup poll that showed at least 32% of Americans actually own a firearm. ATF agreed that its data was outdated, acknowledging that one public commenter suggested the department use a more recent survey which showed that the number of U.S. adults owning a firearm was 32%. The department concurred and has updated the estimated population of individuals owning a firearm from 22 to 32%. You may be asking, why does this matter? Well, ATF purposely used outdated study data to show that their rule would affect fewer people. They underestimated the number of gun owners in the U.S. by 10%. That's a significant difference. They've done this before with their pistol brace rule, claiming there were only about 3 to 7 million braces in circulation. Meanwhile, a Congressional Research Service report put out a more accurate estimate that there were closer to 40 million pistol braces in circulation. ATF does this because they know that a rule that affects more people has a stronger chance of being overturned, whether through congressional action or from the court system. So they attempt to minimize the number of individuals affected through bogus estimates and bad data. This time, thanks to our comment, we stopped them. So there you have it. Those are just a few ways that ATF had to respond to some of GOA's comments. And as you can see, these comment periods are extremely important. Unfortunately, we know that this isn't the last rule the ATF will ever release. There are more on the horizon. GOA stands ready to fight these unconstitutional abuses in every way we can. And during these notice and comment periods, we rely on the support of our members to leave a comment and show how they're affected by these rules. As you can see, it goes a long way even if the rule does take effect. It even helps our lawsuits as well. So please consider becoming a GOA member and help us fight ATF and the billionaire-funded gun control lobby. That's it for today. Thanks for watching.